Hello and welcome back to the channel. You may have heard whispers, seen headlines or read policy proposals about the UK government looking to tighten immigration rules further. There has been significant discussion about extending the qualifying period for settlement or ILR from 5 years to potentially 8 or even 10 years for certain routes. The Home Office's approach is becoming more stringent, scrutiny is intensifying, and the concept of a probationary period before settlement is gaining traction in policy circles. So today we are breaking down the 5 most critical reasons your indefinite leave to remain could be cancelled. Getting your ILR is one thing, keeping it is another. And this is information everyone with ILR or on the path to it needs to know. Before we get there, only about 1% of my total viewers are subscribed to my channel. Please subscribe to the channel as this gives me motivation to create content just like this one. Alright, let's dive into our first reason, and it's one of the most common traps people fall into: excessive absence from the UK. Many people believe that once they have ILR, they are completely free to travel as they please. This is a dangerous misunderstanding. Under current immigration rules, your indefinite leave to remain will automatically lapse if you are absent from the United Kingdom for a continuous period of more than 2 years. 2 years might sound like a long time, but life happens. A family emergency back home, a lucrative multi-year job contract abroad, or simply deciding to travel for an extended period can easily push you over this limit. Now, how does this connect to the stricter environment we're talking in? First, border systems are fully digitized. The Home Office has a precise record of your entries and exits. There is no ambiguity. The Home Office can, in very specific circumstances, allow you to return even after a 2-year absence. But the burden of proof is incredibly high. You would need to demonstrate exceptionally strong ties to the UK, like family, property, and a life you fully intend to resume. Relying on this discretion is a huge gamble. Treat your ILR as a residency permit, not a lifetime re-entry visa. If you plan to be away for a significant period, you must be acutely aware of that 2-year clock. This next reason is arguably the most powerful and far-reaching tool the Home Office has, and its use is on the rise. Reason number 2 is deception, or the use of false representation. This is not just about lying on your ILR application. Under Section 76 of the Nationality, Immigration and Asylum Act 2002, the Home Office can revoke your ILR if it is found that you used deception in any previous UK immigration application that led to your grant of ILR. An inconsistency on your first student visa application from a decade ago, or an inflated salary figure on a skilled worker visa application from 6 years ago could come back to haunt you long after you've received ILR. So, why is this more relevant now and looking towards 2025? 2 words: data matching. The Home Office is now systematically cross-referencing immigration data with records from other government departments, most notably HMRC, the Tax Office and the DWP Department for Work and Pensions. Let's imagine a scenario. On a visa application in 2020, you stated your salary was £35,000 to meet the threshold, but your HMRC records for that year show your actual earnings were only £30,000. 5 years later, you have ILR and think you're safe. But a routine data matching exercise flags this discrepancy. The Home Office can then open an investigation and conclude that your ILR was obtained through a chain of applications tainted by deception, giving them grounds for revocation. With a potential 10-year path to settlement in the future, that's a full decade of your life, your applications, and your data under the microscope. Every form you've ever filled out, every document you've ever submitted, becomes part of a permanent record that can and will be scrutinized. This is not about simple, honest mistakes. This is about information, whether provided intentionally or recklessly, that was material to a decision. The message is clear: your entire immigration history must be clean. Reason number 3 is a broad but critical category: criminality and conduct deemed not conducive to the public good. This is more than just avoiding serious crime. The rules are split into two main parts. First, there's automatic deportation. If you are not a British citizen and you are sentenced to a period of imprisonment of at least 12 months, the Home Office is legally obliged to issue a deportation order against you. This automatically revokes your ILR. But the second part is where the grey area and increased scrutiny lie. The Home Secretary has the discretionary power to revoke ILR and deport someone if they believe their presence in the UK is not conducive to the public good. In an era of stricter immigration control, the interpretation of what is not conducive to the public good is hardening. The government wants to demonstrate that settlement is a privilege reserved for those who are law-abiding and will integrate it. A criminal record that might have been overlooked a decade ago could now be viewed as grounds for revocation. If the ILR track is extended, it means a longer period during which your conduct is assessed. A mistake made in year 8 of the 10-year journey could jeopardize everything. The standard of good character isn't just for citizenship anymore. It's becoming an ongoing requirement for maintaining your settled status. This fourth reason is a painful one because it can happen even if you, personally, have done nothing wrong. It's the revocation of your ILR because the person on whom you were dependent has had their status revoked. Let's break this down. Imagine a family where one person is the main applicant, let's say a skilled worker and their partner and children are their dependents. They all go through the 5-year route and are all granted ILR. The family is settled and happy. 2 years later, the Home Office discovers that the main applicant used deception on their original visa application, like we discussed in Reason 2. The Home Office moves to revoke the main applicant's ILR. Here's the crucial part. Because the partners and children's ILR status was granted on the basis of their relationship with the main applicant, their ILR can also be revoked. It doesn't matter that the partner and children were completely innocent and unaware of the deception. The immigration status was tied to the main applicants, and when that foundation is removed, the entire structure can collapse. In a stricter immigration environment, and especially with the potential for longer routes to settlement, the web of dependency becomes more complex and extends over a longer period. This highlights the immense responsibility on the main applicant. Their actions, past and present, carry consequences for their entire family. It's a stark reminder that in the eyes of the Home Office, a family's immigration status is often a single, interconnected entity. Our final reason is slightly different. It's not about losing ILR after you have it, but about having it refused or cancelled at the very last second, which is just as devastating. This is the revocation of your existing leave because you no longer meet the requirements at the time the ILR decision is made. This is particularly relevant for those on a 5-year route who have applied for ILR and are awaiting a decision. You are not safe until that biometric residence permit showing indefinite leave to remain is in your hand. For example, let's say you're on a skilled worker visa. You meet all the requirements, apply for ILR, and while waiting for the decision, you are made redundant from your sponsored job. Even though you met the criteria on the date you applied, the Home Office caseworker Command often will review your circumstances as they are on the date of decision. If you no longer have that sponsored job, they can argue you no longer meet the requirements of the route you're on, refuse the ILR, and even curtail your existing leave, giving you just 60 days to find a new sponsor or leave the UK. The same applies to the family visa route. If you apply for ILR as a partner, and the relationship breaks down before the decision is made, your application is likely to be refused. With a potential 10-year route, this risk is magnified. That's a much longer window in which your life circumstances, your job, your relationship, your salary can change. It makes maintaining perfect compliance with your visa conditions right up until the moment of decision absolutely non-negotiable. The purpose of this video isn't to scare you. It's to empower you with knowledge. Indefinite leave to remain is one of the most valuable statuses you can hold in the UK, and it deserves to be protected. The key takeaway is that ILR is not a fit and forget document. It requires ongoing vigilance. Be mindful of your time outside the UK, be absolutely certain that your entire immigration history is truthful and accurate, and continue to be a law-abiding member of society. As the government continues to refine its immigration policies towards 2025 and beyond, these areas of scrutiny will only intensify. If any of the points we've discussed today have raised concerns about your own situation, the single best thing you can do is to seek professional, regulated legal advice from an immigration solicitor. Thank you so much for watching. If you found this video helpful, please give it a thumbs up and consider subscribing for more essential updates on UK immigration. Let us know in the comments if you have any questions or what topics you'd like us to cover next.